Miss Martindale, are you okay? You kind of tripped.
Oh,
You okay, Miss Martindale?
yes.
Good. Miss Martindale, you're charged with battery, touching, or striking a battery, and then kidnapping, false imprisonment. That's why you're in jail. Do you wish for me to appoint the public defender if you qualify financially?
Cindy is not Sandy.
Sandy. You're
Right.
you're Bailey Martindale?
This should be Maureen Romero.
It should be
Marine? Okay, I'm sorry. Thanks, Miss Martin.
Right.
Okay, where am I looking?
She's number 9 on the arraignment docket, 1
Your son's not an idiot. He's very smart. He is very beautiful blue eyes, isn't he?
I've got Victor Robinson on, Romero, okay? Maureen,
Yeah.
Maureen,
Kind of.
Romero.
Like, he worked very hard.
Okay, Mr. Romero, you're not charged with those things. You're charged with burglary of an unoccupied
What are you
container.
talking about?
Okay, do you understand?
Yes, what are you talking about?
Okay, so Mr. Romero, do you want me to appoint a public defender if you qualify financially?
Well, you know what? It's okay. Robert's mom will take care of my grandma. Okay, my grandma will take care of her. She's in Tennessee, so it'll make more sense. Okay. So what else you need to know?
Okay, so you're going to hire a private attorney?
Yes, actually, I would just self-represent myself because I'd rather not have a public pretender any day.
Okay, you certainly have the right to represent yourself. When will Ms. Romero be in court next?
May 8th.
Oh,
Okay.
the floor is 39.
So she'll be in my court.
Yes, sir.
Okay. Ms. Romero, you'll be in my court, hold on one second. You'll be in my court on May 8th at 9 o'clock if you're out of jail. If you're not,
Yes.
if you're still in jail, then they'll bring you before me on the afternoon of May 8th. You know, that's a long time. Certainly think about hiring a private attorney. If not, if you file something representing yourself, a motion, then I'll set it for a hearing before May 8th, okay?
Right. But what if I said that Robert already knew all of that and all he wants to know is that his mom is going to be safe at night?
Okay. Mr. Romero, have you ever, you talk a lot. Have you ever had
All
any,
the time, because I get really tired of hearing Robert in my left ear and my right ear too.
okay. Have you ever had any psychological problems? Has anybody ever treated you or anything?
Yes, actually, the hospital in Fort Walton did, and they're going to tell you, I've checked every single box for Robert, except for he's only been to my hospital one time, and the only thing he has is literally PTSD. That's it.
Okay, and so who is Robert?
Robert Smirnoff Romero is what we're going to call him, because he'd rather smear off all the white stains and never worry about anything else in jail.
Okay, is that the alleged victim? To the
No, he's
state?
not alleged anything. He's a real man. He's 18.
Okay. Ms. Romero, I'm going to ask for pretrial services to,
Pretrial services. Why do we need pretrial for not a child?
okay, I'm going to ask them to come talk to you and do a mental health evaluation just to make sure that we're on the right page. okay?
Who's that in the background?
That's the public defender and the state attorney. You can see them in the,
The colorful ones.
oh, and I'm sorry, Miss, I don't even have my camera going, so that's not good.
Oh, okay, here, let me see a little bit more, of course.
There you go. Now you can see me. I'm sorry, ma'am. So I'll ask mental health pretrial to just talk to you, and then they'll give me a recommendation if I need that. Otherwise, I'll see you no later than May 8th, okay?
Judge,
Yes,
was
ma'am.
there already an evaluation? Because I see there was an MH case that was open after this case.
Okay. And so has mental health pretrial been appointed or ordered to, is there anything that she needs to do?
It looks like there's also another case that's getting transferred down here from.
Upstairs are down, so that means you do not want to serve anything of a microphone, because if you do, then they're going to work. Yeah, Jay, but day to day is going to say, hey, yeah, leg day, with if you look at the left, right hand, things are like, no. But you
Okay,
don't
hold
know-
on, Mr. Romero, hold on. So I'm talking to the state, I'm trying to, so if mental health pretrial is appointed, then why shouldn't the court just appoint the public defender?
I don't see that mental health pretrial has been done.
Okay,
My concern, Judge, just based on the fact that she wasn't able to be transported this morning due to her combativeness and her presentation here on Zoom today, it seems that a competency evaluation would be more of the direction to go rather than just a pretrial service. Because pretrial service, mental health evaluation, I'm just going to say if she's released on bond, if she gets services, which is not going to happen because it looks like she's wanted out of Tennessee, so she's going to remain on the detainer for that.
I've never, I don't think I have, I don't think I've done a mental health evaluation just sua sponte without an attorney seeking one.
The court, upon its own motion, can appoint an expert for competency reasons.
Okay, good, then I do that. Thank you, both of you. Mr. Romero, so a psychologist or a social worker will come talk to you, and then they'll provide me with the outcome of that. Again, I'll see you no later than May 8th, but I'll probably see you in a few weeks, okay?
Oh, okay, so yes, for healthcare and free mental health services and facilities, but if you don't know 5 and 4 odds, you're gonna say only 3 of them will seek help, which is actually more statistically impossible than anybody. Men choose not to seek help, women choose to seek help. Men trust women, makes more sense that way.
Well, they're gonna come talk to you and ask you some different questions and give me their expertise.
And I'll tell you, that's just Robert's mom. Robert's mom has always cared about us.
Okay, thanks, Mr. Romero. I'll see you no later than May 8th.
Have a good one. Thank you.
Thank you, Jack. Okay. Is Jose Livia Argenet? I'm gonna butcher that last name. Argueta, I think. Jose Argueta? David Makoff?
Yes, sir.
23 CF 402. Good afternoon, sir.
How are you doing, sir?
You're doing well. You're charged with trafficking in amphetamines, possession of marijuana greater than 20 grams, possession of narcotic equipment. Do you wish for me to appoint the public defender if you qualify financially?
I'm trying to hire somebody right now.
Okay.
I haven't quite got to that point yet, but can you get a continuance so
What I'll do is I'll put a denial in for you,
okay.
and then we'll just schedule it for the pretrial on May 8th at 9 o'clock.
Maybe it's not fun.
If you're going to hire a private attorney, do it sooner than later so they can start working on your case.
Yes, sir.
If you decide that you can't afford an attorney or don't want one, fill out a financial affidavit at the clerk's office, and the clerk will let you know if you qualify financially.
All right.
Okay?
Thank you,
So
sir.
May 8th, 9 o'clock.
Maybe it's not fun. All right. Thank you very much.
Thank you, sir. There, Mr. Martindale, please come on down. 23 CF 425. Mr. Martindale, you're charged with battery and also kidnapping, false imprisonment. Do you wish for me to appoint the public defender if you qualify financially?
Yes, Your Honor.
How much money do you make per month?
Roughly $2,400, I believe, per month.
Okay,
I make $18 an hour.
okay. what we need to do is fill out a financial affidavit, because for that amount, I just can't tell you that you qualify. So if you'll fill that out before you leave, and, turn it into one of the bailiffs. If the clerk says you don't qualify, you're really close to the line, I would suggest that you appeal it to the judge, and because we have more latitude than the clerk does, we can look at the totality of it and say whether you qualify or not.
Okay, and that would be to you, Your Honor?
I'm sorry?
That would be to you?
I don't know whether it'll come to me or it'll go to another judge, but one of the judges will look at that.
Okay, yes, sir.
Okay? So if you'll turn it into the bailiff before you leave, and then I'll see you back here on May 8th at 9 o'clock.
Yes, sir.
Thank you, sir. Okay. So, Mr. Martindale, what I just learned is that if you'll fill that out and then take it down to the clerk's office on the first floor, they will tell you immediately whether you qualify or not. If you turn it into me, then, or to the clerk here, then they mail it to you. So if you want an answer sooner than later, and then you can also, I would suspect, appeal it down there. Okay. So then you can immediately appeal it. At the bottom of it, you can ask the court to review it.
Okay.
So if you'll fill it out, go down to the clerk's office on the first floor.
Yes, Your Honor.
Okay? But May 8th, 9 o'clock in any event.
Thank you, sir.
Thank you, sir. Okay, then Morris came off. Nesmal came off. And I think, nope, Victor Robinson. I don't see Mr. Robinson. Romero, we
As
already
it
did.
relates to Victor Robinson, we have an active misdemeanor FTA for a county case.
Okay. Derek Smith, Derek Samuel, yes, sir. Come on down, Mr. Smith. 23 CF 399. Hello, Mr. Smith. Does the state have an offer for Mr. Smith?
Adjudication of guilt and credit for time served, Judge, for a plea today.
Okay. Mr. Smith, have you ever been adjudicated guilty of a felony?
Yes, sir.
Okay. So what the state's offering is an adjudication of guilt and then credit for time served. You'd have to pay the court cost, and then your case would be resolved today. If you want me to appoint a public defender, I can do that. If you want to represent yourself, you can sure do that. It's up to you.
Excuse me, so just pay a fine, that's it?
You would be paying the court cost. I'd ask you how long in order to pay that, and you would be adjudicated guilty, and you'd just be sentenced to time served, so you wouldn't go out the side door. Mr. McKinney's about to jump out of his seat, so if you want to listen to him a moment.
That's fine.
Okay, so, Mr. Smith, you do want to accept that?
Yes, sir.
If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. So, Mr. Smith, if you accept the plea and the court accepts that, then you're waiving your right to a trial by jury. Do you understand that?
Yes, sir.
You also are waiving your right to an attorney.
Yes, sir.
Okay, do you have any questions for me or the state?
No, sir.
Mr. Smith, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court costs. Madam Clerk, how much for those?
$515.
So $515. How long will it take you to pay that, Mr. Smith?
Month or two?
Okay. Why don't we do 90 days, okay? If you fail to pay it within 90 days, then it would go to a civil lien or judgment. Okay?
That was how much again, sir? I apologize.
$515. You can talk to the clerk about doing a payment plan if you want to do that. As long as you pay it within the next 90 days, then it won't go to a civil lien. Okay? Thank you, sir.
Judge, I'll just write a whole sheet, but there's no presumptive.
Good. Thank you. Benjamin Ward is next. 23 CF 398. Hello, Mr. Ward. Does the state, well, probably doesn't have an offer from Mr. Ward that he may want to accept. Mr. Ward, do you want me, you're charged with possession of a controlled substance without a prescription and also possession of a weapon by a convicted felon. Do you wish for me to appoint the public defender if you qualify financially?
Yes.
How much money do you make per month?
I'm on disability over $800 a month.
I do appoint the public defender. Mr. McKinney's approaching on your right.
Judge, I have provided my contact information at this time. Wesley McKinney on behalf of Benjamin Jackson Ward. We will acknowledge receipt of 2 count information of David's formal arraignment or plea not guilty. This is scheduled for May 8th. We'd like to leave it on that court date.
Yes, sir. Mr. Ward, I'll see you on May 8th at 9 o'clock.
All right.
Thank you, sir. Justin Watson is next. 23 CF 407. Hello, Mr. Watson. Good, how are you? Mr. Watson, you're charged with cocaine possession with intent to sell or manufacture, marijuana not more than 20 grams, and then paraphernalia. That's why you're here. Do you wish for me to appoint the public defender if you qualify financially?
No, sir, I'm actually in the middle of hiring a lawyer.
Okay. So then I'll see you back here on May 8th at 9 o'clock. You heard what I said to one of the other defendants. Get the private attorney on board sooner than later so that they can talk to the state and advise you before May 8th. If the state offers you something that you think's in your best interest and you want to accept it before May 8th, you'll avoid about 300 or 400 people, and your attorney can set a hearing before then.
Yes, sir.
Okay? Thank you, sir. Jennifer Wilson is next. 23 CF 424. Does the state have an offer for Ms. Wilson? Hello, Ms. Wilson. It's driving while license suspended, habitual second or subsequent.
It was going to be a withholding probation offer, Judge. Should probably talk to somebody about that.
Ms. Wilson, do you wish for me to appoint a public defender? Let me first off ask you, have you ever been on probation before?
Yes, sir.
Okay. Do you know how long, Ms. Davis, you're offering for Ms. Wilson to be on probation?
Not right offhand, Judge.
Okay. Ms. Wilson, do you want me to appoint the public defender if you qualify financially?
Yes, sir. I have an application complete, but I was told to bring it.
Okay, good. Do you have it on you?
Yes, sir.
You'll hand it to the bank. Thank you. Thank you, sir. So you receive about $2,800 per month is what you make?
Oh, no. Is that what I heard?
But it's bi-weekly, so that'd be $14.
Oh, then no. I make about, my paycheck is around $1,600 every 2 weeks.
Okay, so that still would be $3,200 a month. And that's about what you make a month?
Yes.
Okay.
I have 2 children and single moms.
Okay. I'll turn this into Madam Clerk. You may not qualify making that much. Usually the break-even's about $2,000 a month. You can certainly appeal that and let the court look at it. If you don't qualify for the public defender, you'll either be representing yourself or you will need to hire a private attorney, okay? But I'll see you back here on May 8th at 9 o'clock. Clerk will let you know if you qualify after. I'm going to ask her to take it down. Is that
There was one spot where she didn't circle. Yes or no?
That's not a salary, so it's not an ongoing, like always the same amount, unfortunately. And to be quite honest, like this week, taking off is $120. So it's like, you know, I don't always make the same.
right? I would do, you know, what do you average making over the last 5 months? How much have you averaged?
I wasn't employed the whole time.
So you just got this job?
Yes.
Okay. Over the last 5 months, what have you averaged making per month?
I got this job 2 months ago. I wasn't working before that at all.
Okay. Gotcha. Okay. Let the clerk notify you. I think you're going to hear that you don't qualify. Appeal it to the court. If that's accurate, what you've got on there, if it's not, and you want to take it back and fill out another one, but be accurate on what you have, okay? If you want to expound on that, if you want to add, I've only had the job for 2 months, but I don't think that'll really help you a lot because that's what you're making now. Okay. May 8th, 9 o'clock.
So who do I follow up with then? With
The
the
clerk will notify you if you qualify or not, and then you'll have a place that you can appeal it at the bottom. You want to get it to her and her take it down?
Well, we will notify you by your email address that you provided.
Do you have any type of timeline? You will? You said.
I would say within the week.
Okay. Thank you.
Thank you, ma'am.
Just be sure your contact information is good.
How do I make sure it's good?
I believe that's all of the pro se's that I have, other than the ones that I passed that weren't here.
Judge, I have Tiffany Lockman in the courtroom.
Thank you. Yes, sir.
Ms. Lockman is present at 23 CF 452. She's represented by Mr. Kleins. I provided his contact information. We would acknowledge the receipt of a 2-count information, waive its formal reading, and or plea if not guilty. This is scheduled for May 8th at 9 a.m.
Okay. I'll see you on May 8th at 9. Okay.
Okay, thank you, Your Honor.
Thank you, ma'am.
Okay, oh, I'm sorry.
Tristan Oja? Oh, yeah. Mr. Oya is here in 23 CF 419, also represented by Mr. Kleins. I provided Mr. Kleins' contact information. We will acknowledge the receipt of a 1-count information, waive its formal reading, and enter a plea of not guilty. This is scheduled for May 8th at 9 a.m.
Mr. Oya, I'll see you on May 8th at 9.
Yes, Your Honor.
Thank you, sir.
Judge, may I call Ryan Tucker?
Certainly. Ryan Tucker. I don't see Mr. Tucker. This was noticed for 1:30. It's now 1:52. This is state. KPs will be issued for Mr. Tucker. And first,
Ryan Tucker?
That's 23 CF 397.
That one has a not guilty plea filed.
Did I do that?
Ryan Tucker was removed from our file.
I didn't have notes that I did that.
Yes, sir.
Oh, well, I guess I did that, Judge.
Okay, so no.
I'll ask you to please not arrest him.
Yes, sir. Okay.
That's all I have.
Okay. Anybody else at 1:30?
Judge, Mr. Jeffers is carried over from this morning's docket.
Good. Mr. Jeffries, if you want to take your microphone off mute.
Judge, we have confirmation from probation that the proof of community service work has been completed, so at this point, we would ask that the violation of probation be dismissed and the supervision be terminated. There will be an outstanding financial balance that will need to go to a judgment or settlement.
Okay. it's restitution only? Or is it both? Okay, well, I guess then restitution will go to a judgment, and I think the other will go to a civil lien, but.
Yes, sir.
Mr. Jeffries, so the violation of probation is dismissed, and so any outstanding financials will either go to a civil lien or a judgment. And it's civil, not criminal, so the criminal case is closed, okay? Mr. Jeffries, could you hear me? Yes, sir, the violation of probation is dismissed, and just all outstanding financials, any money that you owe, will either go to a civil lien or a civil judgment. So you can talk to the clerk about setting up a payment plan for any of the amounts that aren't restitution, but the restitution will go to talking to myself.
Was probation terminated or terminated remote?
Yeah, terminated. Victor Robinson, I know we talked about that he has a KPS already. Are we issuing a KPS on this one?
Okay. Mr. Robinson?
Yes, Judge.
Okay. KPS will be issued for him and the first appearance judge. We'll determine the bond. Okay. Anybody else on the 130? We had Jose Argueta, 23 CF 383. I don't believe it's here. Correct. Notice for 130, it's now 155. KPS will be issued for Mr. Argueta. Did we do David Mackoff?
Yes, Your Honor, he appeared.
Good. Anybody else from the 130? Okay.
If I may ask the clerk, what was the status of Avery Morris and Brandon Mallon?
Avery Morris, there's a not guilty plea filed by Jay Patel.
Okay.
And what was the other name?
Brandon Mallon.
Not guilty plea filed by Christopher Garrett.
Okay. Thank you.
You're welcome.
Mr. Stevens, are you ready?
I am.
Please. Mr. Jeffries, can you hear me better now? If you can, if you'll unmute your microphone. Mr. Jeffries? There you go, good. Mr. Jeffries, so the violation of probation was dismissed. So, and then your supervision, you're not on probation anymore, it's terminated. All outstanding financials will go to a civil lien or a civil judgment. So you don't have any more probation, there's no more criminal case, just the outstanding money. You can talk to the clerk about a payment plan for any of the court costs, and then there'll be a civil judgment for the restitution. Okay?
Is that still the 333 that was set last month, or is that the original balance?
I don't know what money.
Probation, do you know what the balance is on? Probation is looking, Mr. Jeffries.
Sir?
Probation is looking to see if they have those numbers.
Oh, okay.
Don't have a calculator, Your Honor, but he has $819.82 to the clerk, and there's another $250 to the clerk. 1982.
Okay.
250 to the clerk,
Okay.
and the rest of it is COS that I'm going to close.
Okay. I thought there was restitution. of what?
Edward Jeffries?
I thought there was 2,000 in restitution. That's wrong? Nope. Okay, so it's just court. Mr. Jeffries, it's a total of $1,609.82. So if you want to talk to the clerk about setting up a payment plan, you can talk to them about paying it off, okay? But it's not a criminal offense if you don't pay it, it's civil. So it may adversely affect your driver's license, but it won't be a criminal violation. Okay? Okay. Thanks, Mr. Jeffries. Your probation is terminated.
Thank you.
Thank you, sir.
Thank you.
Okay. Yes, sir, Mr. Stevens.
David Stevens on behalf of Tina Gore, 21 CF 2929. We do have a plea and sentencing agreement to file with the court. In count 1, it will be a plea to lesser included offense of burglary of a structure. She will be adjudicated guilty, serve 9 months of Okaloosa County Jail with credit for all time served, $150 legal assistance fee, $615 in court costs, all costs within 180 days of release. Count 2 will be a plea to lesser included offense of improper display of a weapon, adjudication of guilt, 9 months county jail with credit for all time served. Counts 3, 4, and 5 will be a plea as charged, adjudication of guilt, 9 months county jail, credit for all time served. All of this direct concurrent with each other, and the state agrees to take no actions on any failures to appear. If I can finish.
Yes, sir. Thank you. Ms. Gore, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Gore, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes, sir.
Okay. Did you sign the plea agreement?
Yes, I did.
Are you satisfied with Mr. Stevens'
I'm extremely
representation?
happy and satisfied.
Ms. Gore, I do accept your plea. You're adjudicated guilty in each count. First 2 counts are the lesser included offenses. You're sentenced to 9 months in the Okaloosa County Jail with credit for all time served. And that's to run concurrent. You run at the same time between each count. You need to pay the $150 public assistance fee and the $615 court cost. How long do you want to pay those 2 amounts after you get out of jail?
I think the agreement said 180 days.
So if you don't pay those within 180 days, then they will go to a civil lien or judgment.
Yes, sir.
Okay? Thank you.
Thank you so much.
And the
Yes,
credit
sir.
for time served too.
Yes, sir.
Because you should have 9 months in already.
Absolutely.
Yes, thank you.
Thank you.
Next should be Jerome Moore with
That's all I have. Thank you.
Thank you, Mr. Stevens.
Ryan Morrow for Mr. Moore this afternoon, Your Honor. There's going to be a negotiated plea on the VOP. Run back and get my hand. Your Honor, the agreement between the parties contemplates that we'll ask the court to accept the defendant's admission on the violation, $100 VOP fee, $150 cost of defense, modify supervision to include 6 months Okaloosa County Jail, credit for all time served, reinstate to original terms and conditions, place back on community control with the GPS, and the GPS will be attached before his release. I'll pause and give my client an opportunity to sign. May I approach, Your Honor?
Please. Mr. Moore, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Moore, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
I did.
Mr. Moore, I do accept your plea. You're adjudicated guilty. You're You'll need to pay the $100 cost of prosecution, $150 public defender's fee. Your current supervision is modified so that you're sentenced to 6 months in the Okaloosa County Jail with credit for all time served, and that's followed by the balance of your supervision with the original terms and conditions. So you'll be placed back on community control with the GPS monitor, and they'll attach the GPS monitor before you leave the jail. Okay?
Yes, sir.
Thank you, sir. And when you get out of the jail, you need to report to probation.
Yes, sir.
Okay? Thank you.
Next will be Melissa Andrews with the Regional Company.
Yeah, Ms. Jacob.
Hi, Judge, how are you?
I'm doing well. How are you?
Very well, thank you.
Judge, this is Melissa Ansley before the court in 2020 CF 2709. This case, I believe the state had filed a proposed order to transfer to Crestview. She's got a new law felony case in Crestview. I have not seen the court signature on that order yet.
Okay.
There is a motion filed, but there is no signature on it.
Okay, but you're making it orally?
I didn't file the motion. I believe Mr. Governor filed the motion.
Probably my clerk that did it. I will make sure that when I get back, I can sign one and then submit a signed one.
Okay, and I just talked to my judicial assistant over lunch, and she said it's sometimes the motions aren't getting filed, and so I said if I do it orally, I will make a note and tell my judicial assistant immediately, because what she does is holds on to the proposed orders until the motion shows up on the docket, and then she sends it to me. So I will make a note, Ms. Ansley, that I'm granting the motion to transfer your case to Crestview. So you'll appear in front of the judge there. Do you have any idea when that will be?
Yeah, whenever your next court date is. Okay.
Okay.
I can do that now.
Okay. Good.
Yeah, Madam Clerk, are we able to just put it on to run concurrently with her other Crestview case?
Oh, yes.
And I don't have that case number, I apologize.
Okay, so that'll be April 24th.
Okay. Thank you, Ms. Ansley.
Thank you, Your Honor. That's all I have. Maybe excuse.
Yes, ma'am. Thank you. Have a great afternoon.
You too.
Brian Marley, Mr. Wesley, we're before the court for sentencing. We're set till 2:30. I don't know if the state's ready to proceed. My witness is here, and Mr. Wesley is here.
Okay, good. Hello, Mr. Wesley.
How you doing today, sir?
Good. Your beard's got longer since I saw you last.
Yeah, I'm trying to change up today. Yes, sir.
Okay, so Mr. Wesley, hold on one second. I'll tell everybody what I read through and Mr. Marley, if you can get me your letters sooner, it'd be great, but I had plenty of time over lunch because we ended early this morning.
Thank you, Your Honor. I do apologize for getting that to you late.
I went through that letter.
I'm sorry, go ahead.
I went through that letter. I also looked through the psychological evaluation by Dr. Zeman. I pulled and printed off the plea and sentencing agreement that was entered on September 22nd of last year. I also looked at the violation report that was filed on October 27th of last year, the April 27th addendum to the probable cause. I looked through that. Also, the violation of the plea agreement that was entered February of this year. And then I also printed off the January 2nd letter that Mr. Wesley sent to me, to the court, and that was filed with the clerk.
Understood. Thank you, Your Honor.
Mr. Barton?
Initially, Your Honor, I would move with the state stipulation to admit what I previously marked as Defense Exhibit 1, which is Dr. Zeman's psychological evaluation of the evidence in the sentencing hearing.
Okay. Have you filed that with the clerk, or do I need to file what you've given me?
I did file it in the discovery, Your Honor. I just wanted to admit it as evidence in this proceeding.
Okay. Any objection from the state?
No objection.
The psychological evaluation that was done by Dr. Zeman.
And may I approach Madam Clerk?
Certainly. Is admitted into evidence as Defense Exhibit A.
A?
Yes, sir. I think we'll use numbers for state
Okay.
and letters for
Thank you for letting me know, Your Honor. I'll fix it.
Traditionally, that's what we do.
Defense Exhibit A, okay,
Thank you.
And would it be all right if I asked Mr. Wesley to join me?
Sure. Mr. Wesley, do you want to have a seat at council table?
If I can have a moment, I'll call my first witness, Your Honor.
Yes, sir.
I'm going to make some corrections on my exhibits. At this time, the defense would call Ms. Brittany Evanoff. And just so the court is aware, Ms. Evanoff does have a small child in the back that she brought with her today. We're hoping it's not going to be a disruption.
Bring her on the stand?
She asked me if she could. I didn't know what the court would prefer.
That'd probably be the best. Yes, ma'am. What is your daughter's name?
Taylor Ray.
Taylor. Hello, Taylor. How are you? Okay. Oh, okay. Scared to block out, but yes. Mr. Martin?
Thank you, Your Honor. Good afternoon, ma'am. Would you state your name? Please display your last name for the record.
Brittany Evanoff, Evanoff.
And what is the nature of your relationship with my client, Mr. Wesley?
He is my fiance.
Okay. And how long have you known Mr. Wesley?
About 2 years.
Okay. Permission to approach the witness, Your Honor?
Yes, sir. We'll show the state first.
I've given the state copy.
Yes, sir.
Would you be so kind as to flip those pictures and tell me if you recognize those photographs?
I do.
And how do you recognize those photographs?
I printed them out, or I sent them to you.
And Defense Exhibit B, what does that depict? They're labeled in the corner.
Our business card.
And C, that depicts what?
Our hair clippers.
And D?
Our trimmers as well, in a case.
I'm sorry, and E?
Taylor Ray.
Taylor Ray. At this time, Your Honor, we move to Defense Exhibits B through E into evidence.
No objection, Your Honor.
They're admitted.
And when you say we, you're referring to yourself and Mr. Wesley. Can you describe what you mean by that?
What do you mean by we?
Right, when you say our clippers.
Oh,
our
him and
business
I,
card.
like, he's the barber and I'm the business manager of
And,
our business, Young Bless Barber.
And can you talk to me a little bit more about what those pictures depict?
I was sending them to Roger to show him the progress that we've made on the business and the clippers that I ordered and the business cards that I ordered and had printed.
And it's fair to say that these photographs, they don't evidence the full extent of your efforts to get the business off the ground. Fair to say?
Say it again?
That's not the only thing that you've done in terms of getting the business off the ground while Mr. Wesley was incarcerated.
No, this is just the smaller stuff. Like, I also had this LLC with the state of Alabama. We have a domain name, youngbloodsbarber.com. the Facebook page, Instagram page, email, Gmail, and EIN number as well.
So you've done a lot of legwork in terms of making sure that he has something to come back to if he's released for
Correct,
incarceration.
yes.
In the way of employment.
Yes.
And entrepreneurship.
Yes.
And you're aware that Mr. Wesley has some mental health issues, right?
Yes,
Now, and you care a lot about Mr. Wesley.
I do.
And it's your intention, if he's released, assuming since you're engaged, that you will cohabitate in the near future after his release. Is that fair to assume?
Definitely.
Okay. And being aware of his mental health issues and caring about him so much, if he was to be recommended treatment, would you see to it that he abided by that treatment?
Yeah, we've discussed that, and definitely whatever the court recommends, we will follow through with.
Whether that be medication or counseling?
Correct, whatever is best for Roger.
And one final point, Defense Exhibit E depicts who again?
Taylor Ray.
And how is that relevant to this proceeding?
I mean, she's 100% part of my life, and so is Roger, so together we will raise. She's this is her business, this is hers. This is the way we provide for her, and she is everything.
Do you feel as though Mr. Wesley is a positive influence in her life?
I do.
Those are my questions, Your Honor.
To the state?
No questions from the state, Your Honor.
Thank you, ma'am. You can step down. Mr. Warren, you want to grab those pictures?
Certainly, Your Honor. May I hand them to the clerk?
Show them to me first. And I'll get Thank you, ma'am. Yes, sir.
Your Honor, this is my client, Mr. Wesley.
What's up, raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir. Please be seated.
Good afternoon, Mr. Wesley. Would you state your name, please spell your last name for the record?
Roger Wesley Jr., W-E-S-L-E-Y.
And you've prepared a statement for the court this afternoon prior to sentencing, isn't that right?
Yes, sir, I wrote it up.
I understand that. Would you like to read that into the record at this time, sir?
Yes, sir. Your Honor, again, my sincere apologies to the judicial staff. Today, I'm asking to have my new lease on life permitted. The preamble starts off as "we the people," and that's where the remainder remains to be revealed in the people. To elaborate, we're given opportunities to express who we are as people. Not to prolong your day, but America has what is called the American dream, which is something achievable by all Americans despite ethnicity, culture, or race. As of recent, some placed in similar circumstances lose that drive to acquire this American dream. After enduring and persevering throughout my life's trials and tribulations, some would say that most would lose that drive after being offered 32 months by a system that is set in place to help we the people. But Honorable Judge Brown, today I present to you me, Roger Wesley Jr., or as the people call me, the Young Blessed Barber. I have dealt with several diagnoses mentally, even self-mutilation. But through it all, I've maintained my faith. God blessed me with my fiance that has contributed mentally, financially, emotionally, and has put forth solid, wholehearted commitment in our business, Young Blessed Barber LLC. Family owned and operated by Roger and Brittany Wesley, in part to pursue our American dream together. And with all things considered, we are praying that you understand the entirety of this situation and allow us a legitimate opportunity to be a positive, productive entity in a society where many have given up when faced with adversity and addiction woes at the likes in which we have. Thank you for your time and consideration. Sincerely, Roger and Brittany Wesley, hashtag Young Blessed Barber LLC.
Does the state have any questions for?
No questions, Your Honor.
Mr. Morrow, any questions for your
I'm
client?
sorry, sir, did you say you had another statement, or is that just a different statement?
That was my letter, but Your Honor, I also want to bring to your attention, this is several different sick calls. I have a bullet in my face. The night I was arrested, I was never given any medical attention. I didn't have, well, honestly, they didn't know, I didn't know for like 2 weeks. There was something like bothering me, like a piece of skin, and I broke the skin and looked inside my tablet at the mirror and seen an entry wound, and I squeezed my face and doesn't put it right there. I mean, this is just evidence of sick calls I put in numerous amounts.
And just to make the record clear, you've been experiencing this fair amount of discomfort because of this.
Yes, sir.
And you've tried to take that. And we're not going to admit those at this time. We're just going to take some testimony from you, Mr. Wesley. It's causing you a fair amount of discomfort. You've tried to take this up with medical, and they've essentially advised you there's something that can be done from inside the jail. And it's your hope that once you're released, you'll be able to deal with that pretty quickly. And I'll just ask you directly, Mr. Wesley, you understand that you have some mental health issues, correct?
Yes, sir.
You diagnosed schizophrenic?
Yes, sir, paranoid schizophrenic.
And if the judge sees right to reinstate you and you seek treatment, you'll abide by that treatment? You're amenable to it? Whether that be medication or counseling?
It doesn't matter, like my fiance spoke about reference to, that's the whole goal back then, that we would accept.
Understood.
She just had a surgery, and like, I have to reciprocate what my family has done for me, like just being able to see that face right now.
And do you feel as though where things stand now, you're in a much better position to comply with the terms of probation?
Very much, very much.
Anything else you would have Judge Brown know before he imposes a sentence today?
Again, just thank you for your time and consideration, sir.
Mr. Wesley, let me ask you a couple of things. When I was doing my homework, and that's why when you talked about the bullet in your face, I had read about that. You put in your letter to the court, you spoke about your family. When did you get engaged?
We have dedicated ourselves to each other. Like that's been a key part of my life for like the last 2 years, literally. This situation wasn't due to in part of an incident that I placed myself in. I actually cut 4 little boys' hair and was at the residence to get paid. And my fiance in part was in Pisco at her dad's, and I could go over. So I was at a residence and the incident happened. And when it happened, the police ran my name and I had a warrant from a VOP. But
I wasn't connecting those two. I just was telling you that I had read through the paperwork, but I was curious when you were engaged, and then is Taylor your daughter?
I'm sure she's my stepdaughter.
Okay.
I see her now.
Yes,
she called me Dad.
I understand. I could tell by your smile. Any questions to the defendant based on the court's question?
Is there no questions, Your Honor?
Nothing for me, Your Honor.
Thank you, sir. Mr. Wesley, you can step down.
Thank you very much.
Thank you. Yes, sir, Mr. Morrow, any other evidence?
No, Your Honor.
To the state, any evidence?
No evidence from the state, Your Honor.
Okay. Argument?
Briefly, Your Honor. I'm mostly just referring to my memorandum. We're asking the court to consider reinstating Mr. Wesley's probation. The court has discretion under the statute to do so. He has a fair amount of time. He was only on supervision for about a month before the VOP was filed. I believe his termination date is in June or July of this year. He still has time on probation, Your Honor. This was initially placed on probation for a FTA that was just before jury selection, I believe. It was not my case. It predated my tenure in Okaloosa County, but I've spoken to Mr. McKinney on this, and it was ultimately a plea to a failure to appear. He was given a county jail sentence on the battery that had been enhanced. It wasn't an aggravated battery standing alone. It had been enhanced based on a prior battery from 12 years ago, is my understanding, and the grand theft auto case was dismissed. So we're really here, Your Honor, on a violation of probation for a failure to appear. So we're asking the court to consider giving him another chance. Now, if the court's not inclined to do that, I think that we've shown by a preponderance that the court can downward depart based on Mr. Wesley's significant mental health issues, his amenability to treatment, and the need for that specialized treatment, Your Honor.
Okay. Thank you. To the state?
Your Honor, I think just to kind of start off with, I believe the score sheet indicated a presumptive sentence of 32.02 months. The agreement, I believe, was that...
And I don't have a score sheet. I know y'all mentioned it, but I didn't see that, and you didn't send me a letter, right?
Unfortunately not, Your Honor. I sincerely apologize. So
the score sheet shows what?
It shows 32.02 months, and I believe that was contemplated in the plea agreement to, in effect, effect kind of act as a cap,
Yes,
is what we agreed on. I think as we're looking at this defendant in this case, this defendant has an extensive prior record that honestly spans decades. He has been to prison multiple times, beginning in 2004, with the last prison sentence ending in 2016. The state originally offered has granted leniency, and this court has granted leniency to this defendant on multiple occasions. This was not the first break that the defendant ever received. In his last case, which is 18 CF 3363, the defendant there was given a downward departure when he entered a plea onto that case. He then failed to appear for his very first sentencing date and then ended up violating that probation. And the state then still gave him the benefit of the doubt by giving him an 1129 as a condition of supervision as opposed to just adjudicating an 1129. I would also note that in that 2018 case, there was a report very similarly done to the one in this one by Dr. Zeman, where Dr. Zeman actually spoke with the defendant and actually spoke about this psychiatric treatment. And that if he was going to be released, he would go get the psychiatric treatment and that would really help him. That was in 2018. Then we come back on this case and he immediately gets this case. So that's one instance of showing that A, he either isn't amenable to going and getting that psychiatric treatment, or that psychiatric treatment really isn't helping him stay out of trouble. In the instant case, the state agreed to a signature bond in order for the defendant to be released from custody. The defendant then failed to appear for the very next court date, despite representing to this court that he would be there. The state then gave him another chance and agreed to another downward departure so the defendant could get a chance at the probation that he requested. The defendant reported the day after his release from custody and then never reported again. And as we heard the defendant testify, while he was absconding, he was living his life as a normal, ordinary person, not having to be held accountable to the probation that was set forth by this court, where the state was being lenient and downward departing and giving that probation. I think it's evident that there exists no reason for a downward departure on this defendant's presumptive incarcerative sentence. The defendant has shown time and time again that he has no regard for the law. He has no interest in following the rules of this court. And I think, importantly enough as well, I think in Dr. Zeman's report that has been provided to this court, I think it's very important to point out on page 3, it states very clearly, despite Mr. Wesley's self-report, I have concerns about his true amenability to treatment for mental health. He has been abusing crack cocaine in lieu of psychiatric treatment and exhibits many features associated with the antisocial personality disorder. I think these factors are likely more relevant as it relates to his mental health than his paranoid schizophrenia. And so there you have a licensed psychologist stating that even though he's self-reporting that this may work, the licensed psychologist has doubts that that's true. So for those reasons, the state requests that this court impose the presumptive incarcerative sentence of 32.02 months.
Thank you. Mr. Morrow?
May I have a moment, Your Honor? This is submitting to the court that he has a much different set of factors and life circumstances than he did in 2018 or any of these previous matters. We're asking the court to consider that. We're asking the court to consider the testimony of Ms. Evanoff, and we're asking the court to consider the testimony of my client. I understand the argument the state's making, but I feel as though that is the best evidence. And if the court sees that it does not have grounds to downward depart, we're still asking the court to reinstate, and the downward departure is no longer necessary at that point, Your Honor.
Yes, sir. Mr. Wesley, I read through your second letter to the court first, and I didn't print that off, but I did read through that. Then I read through the first one, and I did print that off. Starting with, and it made got a lot of traction with the court. Certainly your fiance's testimony does too. And the way that you come across, you've got a great smile. You're very convincing in the way that you talk. So I look at things chronologically. April 27th of last year, the probable cause talks about the striking of the victim there, about the face, the victim jumping out of the car, those things. But then I did note that it appeared that you sought to return the vehicle to the victim's father's residence. I read that in there, so I thought, wait a minute, okay. So, and there isn't anything in that addendum that talks about the injuries to the victim. Doesn't say anything about the severity. It just says striking him on or about the face. So then I look at what the plea agreement was. The grand theft was null pros by the state, and probably for that reason. Then the felony battery and the failure to appear were as charged. So I don't look at the grand theft because it was null pros. I don't take that into consideration in my sentencing. When I looked at the October 27th violation report, it says you owed $80 in cost of supervision, absconding, and it says on or about October 24th. They didn't know where you were. I looked to see how long it was between October 24th and the date that the probation officer filed the report. It was only 3 days later. But then I look at the narrative that's under that, and it could be argued that really the violation of probation was greater than 30 days because they couldn't get in touch with you since September 23rd of 22. So from September 23rd to October 24th, it's 30 days of absconding. Read about the Marina Bay Resort. That just again talks about whether you were there, whether you weren't there. She didn't recognize you. They talked to your mom, your dad. Failure to comply with instructions, probably just similar to what the absconding, that you didn't do what the probation officer asked, didn't do community service out. Then I did look at the criminal history that's in that report. Note that there's a lot of, it appears to be duplicates in there because in 2011, 2010, grand theft, trafficking in stolen property. It is interesting because there are different months of when the supervision was. I really don't, I took a lot of that as being duplicitous, being the same thing over again. The next thing that I looked at was your letter. Honestly, sir, I'm asking for 1 year probation with the hope that I would be strong enough to utilize. Oh, honestly, sir, I asked for this 1 year probation, the prior 1 year probation, because you were trying to get clean.
Thank you, sir. Sorry about that.
And so, then you say approximately 2 weeks after that, then you experience some depressing separation with your fiance.
Yes, sir.
And then you went back and did cocaine, I believe.
Yes, sir.
On February was this plea with the cap. And then again, I looked at the psychological evaluation and at your attorney's letter to me. And I did make note of what the state quoted. I have concerns about his true amenability to treatment for mental health. That, in addition to the limited evidence that I have, I don't find that there is a valid reason for a downward departure. And if there is one, that the court shouldn't downwardly depart. But as your attorney states, I can modify your supervision, your probation, without finding a valid reason for a departure. The reason why I asked you the one question of how long you had been together with your fiance was you put that in your letter. You said, I've got a family, I've got a child.
Yes, sir.
But the problem is those predate the time that you were in absconding status. So it wasn't something that You got out of prison, there was some period of a number of 2 or 3 years, you develop this family, you have the child, that gives you impetus to do better, and then, or that you committed things before doing those things, and then that would be new motivation for you to follow the law. I just don't find that, so I don't find a valid reason that I can depart as far as modifying your supervision with violating your probation 2 months after, actually maybe a month after you were sentenced to that. You're adjudicated guilty. You're sentenced to the 32.02 months with the Department of Corrections with credit for all time served. There's a $100 cost of prosecution, $150 public defender's fee. Mr. Wesley, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. You cannot afford an attorney to represent you for that appeal. One may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Okay. Prior supervisions are revoked and terminated. All financials will go to a judgment or civil law.
Thank you, Your Honor.
Thank you. Okay, from shortest to longest, what hearing do we want to do next?
Judge, I apologize. We do have one more from this morning.
Okay, at 1:30 or this
Yes, sir. She gave us paperwork here. It was, he's being patient.
Leave it our kid.
Yeah.
I think it's Xavier, starts with an L.
Yeah.
Okay, so Jose Argueta, is he present?
Pretty sure it's second class.
Argueta, Jose Enrique.
Argetta. Jose Enrique.
23 CF 383. The,
Alejandro Martinez Ramirez.
nope,
But he's here for the state of Florida versus.
does it have a case number, Pat? That's not.
23 CF 383.
That's it? Okay.
He's not the
Okay,
defendant.
so, earlier the bailiff had brought me that notice to appear and asked if they needed to be here. I let you know that that was the bond depositor, not the
You're
defendant.
Alejandro.
So then
You
I
are.
received an email stating that they're back up to the courtroom.
That's you? He-
So I guess we.
This is him, Your Honor.
Okay.
It was-
Good. Thank you, Cool.
He showed me the notice to appear. It's the young lady that was sitting next to him is
Okay.
the Alejandro Martinez Ramirez. Her. You speak English back there?
Do you speak English?
Spanish?
No. Spanish. We're going to do the language one? Mike, do you know how to get the language line on Zoom?
No, we just do it on the phone.
Phone doesn't work very well. They do it, duty judge does it on on Zoom and it works great. Pat, you don't know how to do language line on Zoom, do you?
Is it in the notebook, the blue notebook up there, Your Honor? Via Zoom? I believe I made that request. That it be placed in those notebooks. If not, I can get it.
Here's the
For a lot
over
of
phone.
money.
Over phone.
If you'll give me a moment, Your Honor, I'll go downstairs to one Bravo and grab the cheat sheet from there and bring it right up to you.
That'd be super.
Yes.
You know how to work it on the Zoom? Thank you.
Right back.
Okay, on the 2:30 docket, Mr. Catalinick's here. Mr. Catalinick, is your hearing going to be shorter or longer?
Your Honor, I have no idea. I didn't file the ratings of a hearing. I just have a notice of, to be present at this hearing today.
For Mr.
I think it's pro se.
Okay. Was Mr. Catalanic just appointed or Mr. Deegan, or was that?
This is a 2004 case, Your Honor.
I understand.
So I wasn't sure, because I never got a notice for this, I don't think.
There was a letter from Mr. Deegan, and he was asking to reduce his supervision by 10 months. Mr. Deegan's on Zoom, so Mr. Deegan, if you'll take your microphone off mute.
It does look like it is pro se.
Okay. Mr. Catalanic, you're not representing Mr. Deegan anymore, correct?
No, Your Honor, but I believe I got the notice for the hearing for Mr. Jason Ray Denman, D-E-D-M-A-N.
Yes, sir. Mr. Deadman's on.
Yes, sir, I am not representing him on this case, on this motion.
Okay. So, Mr. Catalanic, do you have anything else before the court?
No, sir.
Okay. Thanks, Mr. Catalanic. I'll just take it up
Thank you,
directly
Judge.
to Mr. Deegan.
I appreciate it. Thank you, sir.
Thank you. Mr. Deegan, so I did read through your letter. You were asking for the court to cut your probation short by about 10 months, correct?
Yes, sir.
Okay.
Yes, sir.
And this is case number 04CF 1527. Mr. Deegan, do you want to testify? You want me to put you under oath?
Yes. Yes, sir.
If you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. How do you pronounce your last name?
It's Denman.
Okay. Mr. Deadman, what would you like for me to know?
Since I've been free, I worked a full-time job, and I made my way as a foreman to the top of the company, and I've also opened my own construction company up. I've been married. I got a son, a 4-year-old son. We have a house together. I mean, life's great. To be honest with you, I think going to prison pretty much saved my life. Everything I learned in there, taking the trades and classes I've got out, put to use. And the 7 years and 3 months I've been free, I've accomplished a lot.
Okay, tell me again, Mr. Deadman, how long have you been out? When did you get out of prison?
I got out January 2016.
And all the things that you just told me about, the family and the job, have occurred after that?
Yes, sir, after, since I've been free.
Okay. What else would you like for me to know, Mr. Deadman?
I just want to let you know that, I really appreciate life now, and they say the felons can't get out of prison and be successful and make a life, and that's not true. I am a convicted felon, and I've gotten out, and I've made it. I've been one of the ones that can say that I've not let my incarceration hold me back from doing anything in life.
Okay. To the state, do you have any questions for Mr. Deadman?
I have no questions for Mr. Deadman.
Okay. Mr. Deadman, anything else you want me to know before I ask the state for their input?
No, sir, I believe that's it.
Okay. Yes, sir?
Your Honor, in speaking of probation, I don't think the state would necessarily have a problem with early termination. However, at this time, there are still only $74 in costs that are still outstanding. I think more pertinently, though, there was an evaluation that was needing to be done. We would have no problem to early terminate, but we want that evaluation done and completed, and to show completion of that evaluation to probation before the state would agree to early terminate.
It's a mental health evaluation or a substance abuse?
Substance abuse evaluation.
Okay, so
and I just wanted to, we're taking this position mainly because of the severity of the charges. And so we just feel as though that evaluation should be completed, and then we would have no problem agreeing to early terminating.
Okay, So, Mr. Dedman, the state wants you to have a substance abuse evaluation, and if that comes back and says that you don't need any treatment, then presumably the state will agree to terminate your supervision. Do you have any thoughts on that?
I have no problem with that.
Okay.
And all my court costs and funds and everything, I've got receipts where I've paid everything that's been due.
Okay.
I think probation would better.
Probation?
Your Honor, he owes $74.88 through JPay to the Department of Corrections.
Okay, you owe $74.88 to JPay to the Department of Corrections is what probation's saying. But more importantly,
I have no problem paying that.
okay, so get the evaluation. So probation, he
Yes,
goes
sir.
to his probation officer and says, I need to get an evaluation. How does he accomplish this?
He's being supervised out of state, Your Honor, so he needs to get an evaluation done. If they determine he does not need treatment, that'll satisfy that condition, but he needs to give that documentation to his officer in Florida. And if they say he needs treatment, then he has to complete it. And then also give that proof to his officer in Florida.
Okay, but as far as him determining who he gets the evaluation from.
He should ask his officer up there.
Okay, so Mr. Dedman, talk to your probation officer there, ask them to tell you who you need to get a substance abuse evaluation from, and then when you get the results of that, the probation officer there will send it to here, is that right?
Or he can send it to his officer.
Or you can send it to the probation officer in Florida.
Okay.
Okay?
And then once the state receives that, we will dismiss.
Okay.
Or revoke and terminate.
Okay. So Mr. Dedman, the ball's in your court, okay?
Okay, thank you.
Thank you, sir.
What was assignment?
This position is that the state stated that they would stipulate to terminating supervision if Mr. Dedman obtains a substance abuse evaluation that says that he doesn't need to do any treatment.
Okay, will this be set for another court date or just?
I'd let him bring it back.
Okay, thank you.
Thank you. English firm?
Yes, sir.
Good. You dial it on there?
I will, Your Honor. I just wanted to check to see if
It's in there? Good.
I saw something that was, yes, this one.
Okay.
There it is.
Good. Thank you, sir.
And there's a code, so there's the code right there. Once we get it broke in.
Okay. Thank you.
Yes, sir.
Mr. Arbretta, if you'll please come up. Thank you. If you're on Zoom, if you'll mute your microphone. Thank you. Got it. Interpreter. Should be coming on down, Pat.
There it is.
Good. Hello to the
Please
interpreter.
hold for the next available. Good afternoon. Thank you for calling Language Fund Solutions. This is Anita May. May I please have the language that you need, please?
Have the language is Spanish.
In Spanish, thank you. And may I please have your access code, please?
Yes, ma'am, it's 222.
Please hold for an interpreter. Thank you for calling Language Line Solutions. This is Manuel. My interpreter ID is 363-679, and I'll be your Spanish interpreter today. I'm ready for your instructions.
Yes, sir. If you'll please tell Mr. Argueta, and it's Argueta, Lavia Argueta. If you'll please tell him that. Go ahead.
Oh, sorry. I was just saying that it's a little hard to hear you. There's a lot of echo in the room.
Okay. Is this any better?
A little better. Thank you.
Okay. Lavia Argueta is the name of the defendant. If you can just introduce yourself to him.
Absolutely. Buenas tardes, me presento, seré el intérprete traductor que les estará apoyando a ustedes hoy.
The reason why you are here is because of the charges of drug possession without a prescription and operating a motor vehicle without a valid license.
La razón por la cual usted se encuentra aquí es por los cargos en contra suya que tiene, que es posesión de fármacos sin una receta y conducir un vehículo sin una licencia.
Does the state have an offer for this defendant?
Yes, Your Honor. At this time,
Sorry. At this time, the state would offer an adjudication withheld, 2 years of standard probation, $615 in court costs, $100 cost of prosecution, a substance abuse evaluation within 30 days, and beginning of treatment within 60 days, 24 hours of community service work.
sí, tenemos una oferta por parte del Estado que serían 2 años de libertad condicional estándar con costos de la corte de 350, así como recibir un tratamiento de abuso de sustancias por 30 días, comenzándolos dentro de los siguientes 60 días y 24 horas de servicio comunitario.
Mr. Argueta, you have the right to an attorney if you want me to appoint one.
Interpreter here, Your Honor, do you be so kind to repeat what you said?
Sure. You have the right to an attorney if you want me to appoint one, if you qualify financially.
Thank you for that, Your Honor. Tiene derecho a un abogado si usted quiere que yo le asigne uno, después de si usted califica económicamente.
You also have the right to accept the state's offer and waive your right to an attorney and waive your right to go to a jury trial.
También tiene derecho a aceptar la oferta por parte del Estado. De esta manera estaría usted renunciando a su derecho a un abogado y renunciaría a su derecho de un juicio como jurado.
Do you want to accept the state's offer? Have you ever been on probation before?
¿Quiere aceptar la oferta del Estado? ¿Ha estado usted en libertad condicional antes?
No.
No.
Do you want me to appoint the public defender if you qualify financially?
¿Quiere que yo le asigne a usted un abogado de oficio si califica usted económicamente?
No tengo efectivo así para pagar un abogado.
I don't have any cash right now to pay for that.
You would have to pay $150 by the end of 2 years if I appoint the public defender. So you don't have to have any cash now.
Tendría que estar pagando $150 al finalizar dentro de 2 años para poder pagar por el abogado de oficio, por lo que no necesita usted tener efectivo en este momento.
Do you want me to appoint a public defender?
¿Quiere entonces que le asigne un abogado de oficio?
The answer is yes. How much money do you make per month?
¿Cuánto dinero genera usted al mes?
$3,000.
$3,000.
You're probably not going to qualify for the public defender making that much money, so I can't say that I'll appoint a public defender for you today.
Probablemente usted no califique para un abogado de oficio si usted genera esa cantidad de dinero, por lo que no puedo decirle que hoy le estoy asignando un abogado de oficio.
I can enter a denial for you today and set this for the next hearing on May 8th.
Puedo emitir una negación para que entonces esto pueda llevarse en una siguiente audiencia el 8 de mayo.
You can fill out a financial affidavit with the clerk downstairs.
Puede usted llenar una declaración jurada económica con el secretario del tribunal en el piso de abajo.
And the clerk will notify you if you qualify for a public defender.
Ya sería el secretario del tribunal quien le notificaría a usted si califica para un abogado de oficio.
If you do not qualify for the public defender, then you'll be representing yourself or you'll need to hire a private attorney.
Si usted no califica para un abogado de oficio, entonces usted se estaría representando a sí mismo o tendría que contratar un abogado privado.
So I will see you back here on May 8th at 9 o'clock in the morning.
Yo lo estaría viendo a usted aquí otra vez el 8 de mayo a las 9 en punto de la mañana.
Thank you, sir. Thank you, Mr. Interpreter. Thank you, sir.
Thank you for using our services, Your Honor. Have a good day.
Thank you, you too. Okay, then from shortest to longest, what hearing do we want to take next?
Your Honor, we have a motion to terminate probation. I don't imagine that would take you very
Okay,
long.
come on, Mr. Drum.
Thank you, Your Honor.
Yes, sir.
May it please the court, Justin Durrell on behalf of Mr. Joseph Sparks. Your Honor, we filed a motion to terminate probation in this matter, and pretty basic, Your Honor. According to Florida Statute 948.04, subsection 4, anyone sentenced to probation on or after October 1st, 2019, which Mr. Sparks was, upon motion by the probationer, the court shall early terminate or convert to administrative probation. And Your Honor, Mr. Sparks has completed, I believe it's 1 year, 8 months of a 3-year probationary sentence, so he's over the halfway mark. Last I checked with probation, there were no outstanding conditions, all fines and costs have been paid, and there's been no violations. Mr. Sparks has held a job at, I believe, what was the name of the bike? Plea Track Bicycles for the last 2 years, so he's had steady employment. Your Honor, we would ask the court to terminate supervision. I don't believe there's any reason to have him continue reporting.
To the state.
Judge, forgive me, I'm going to have to read a little bit. This is actually Ms. Barrickman's case, and excuse me, Barrickman. So she sent me some notes to present to the court today regarding the situation. At this point, the state's going to object to the motion for early termination. The defendant was placed on 3 years probation on July 19th of 2021 for failure to report or protect from child abuse. In exchange for the plea, the authority figure soliciting or engaging in a romantic relationship with a student was dismissed. The defendant is scheduled to terminate on July 19th, 2024, 1 year and 4 months from now. So the defense and the state agreed on a 3-year probation sentence for failure to report child abuse in exchange for the plea, including a dismissal of count 2. As part of the agreement, the plea terms included the defendant having no contact with the victim, do not work or engage in any coaching or teaching involving minors, and to have no unsupervised contact with minors with the exception of family members. So there are still terms that are currently ongoing, Judge. The state would note that the terms in place are primarily safeguards for the community and the victim, things the defendant cannot do while on probation rather than classes or requirements of that nature. Those safeguards would no longer be in place should the court choose to early terminate the defendant from probation. Additionally, the basic allegations of this case were of a sexual nature with a live minor, not an undercover officer. And in accordance with Marcy's law, the state has reached out to the victim's family and Mr. John Moore, the victim's father. He should be present today. Did you want to speak? Yeah. Would you like to? Mr. Moore wasn't sure if he wanted to speak, but my understanding is that he would, Judge. Okay. So.
Mr. Moore, if you'll come to the stand. Yes, sir. Please, if you'll be seated and speak into the microphone.
Mr. Moore, can you state your name for the record?
John Moore.
And Mr. Moore, you are the father of the victim in this case, is that correct?
I am.
Now, what is it that you would like the judge to know when making a decision on this motion for early termination?
I would like for you to know that there are a lot more details that you did not hear from this case. This was a trusted teacher of my daughter's. And at the time that my daughter started her 8th grade school year, she was 13 years old. Her mother just found out she was stage 4 terminal cancer. And so as she's watching her mother wither away, which I believe he knew. Okay? There were instances where my wife got all the attention in the house because she needed the medical care. My daughter probably did seek a little bit of attention. She didn't want to come home because she didn't want to see her mom die. This all came to light to me on December 11th, which apparently from the arrest reports, this started around October, beginning of the school year, I don't know. Comes light to me on December 11th, so right before Christmas, which was my wife's last Christmas, we find all of this out. My wife passed January 26th, so for a month and a half, that's all that's on her mind while she's dying, is what's going on with her daughter, what happened to her daughter. I don't think my daughter ever got to mourn my wife, her mother, properly, because all of this went on. Now, DFS showed at my house after the neglect and stuff like that. We invited them in with open arms. We had nothing to hide. You know, if a teacher would have reported this when they should have, maybe my daughter could have got some help sooner and not lived through all of this. I know that my daughter still is living through this. Middle school girls, I mean. She was ousted by all her friend groups. So when she's mourning her mother, she had no friends. They all make fun of her for this. You know, all the rumors that flew around for this, she had to live through.
Mr. Moore, if I can just direct you for a second. My understanding is that your daughter still has some issues based on what happened in this case.
Absolutely, and who knows what's going to happen in the future with her issues. I think she's doing better this year than she ever has, but we've been fighting, and she's still living it.
What kind of issues has your daughter been having from this?
Well, just all kinds of issues. She wants therapy, she seeks therapy, she feels like she needs to have a therapist. The Child Advocacy Center in Knoxville was wonderful for her. She loved it. My problem was, she's in 8th grade. I can't send her, the kids are so mean down here after all of this happened. I couldn't send her to school. I moved her back to Missouri. I'm all she's got. She doesn't have the friends. She couldn't get into that routine of school again. COVID helped with that, but she didn't have that routine of school, and she still struggles.
So you had to relocate because of this case, or are you back in the area?
I relocated. By chance, Karma, call it what you want, came down for spring break. She's on spring break. I got the phone call about this 2 days ago, and I just happened to be in town. And I would love for the court to know that if you let him on probation, my daughter's still living on probation. And she still will be. She's got nothing out of this. And I don't understand what the need for. Because, it looks like one of the major charges got dropped. And the only thing we're working on here is a failure to neglect. I feel like it was a slap on the wrist. You want to get the slap on the wrist to be softer now. I think, take what you got. You got love.
The state.
I don't have any other questions.
Mr. Durrell, questions for Mr. Moore?
Just briefly, you said your daughter has requested therapy. Are you providing any therapy for her? Mm-hmm. So she is currently in therapy.
She went to the CAC every week that we stayed in Florida, and then I paid out of my pocket for the therapist in Missouri.
And she's continuing to see that therapist?
She is.
Okay. And I believe you testified you have moved to Missouri, so your daughter is no longer in the area?
No, she's with me this week. She has no idea where I'm at right now, but.
No further questions, Your Honor.
Okay. Thank you, Mr. Moore. You can step down. Any other evidence from the state?
No, Judge, just to finish up the notes that I have, Your Honor heard at this point that the victim's father, on behalf of the victim, objects to the motion for early termination. We would note that the defendant received a significant break up front by being allowed to plead to the non-sex offense charge, and the state believes it is appropriate. He served all 3 years of the probation that he agreed to as a negotiated plea.
Thank you. Mr. Durrell?
Yes, Your Honor. Well, quite candidly, Your Honor, whether the state believes or that he should, it ultimately doesn't matter in this case, as this is strictly bound by Florida statute 948.04. The subsection 4 uses the mandatory shall. It's unfortunately not up to what the state believes, as long as Mr. Sparks meets the criteria. Notably absent from that criteria is whether or not the victim objects. I understand that emotions are high in this matter, but I believe the statute lays it out quite clearly with its mandatory language and the subsections A through E. And I can read them out if the court would like.
I'll read it. Thank you. When you said shall, I missed the case number, the statute number, so I'm glad you gave it to me later. Certainly, whenever you say shall, we all understand that that's mandatory, so I wanted to read it.
Yes, Your Honor.
D of that statute states the parties did not specifically exclude the possibility of early termination or conversion to administrative probation as part of a negotiated sentence. Just point that out to the state. Let me finish. Probationer doesn't qualify as a violent felony offender of special concern. Mr. Durrell, what about parens 5 that says upon making written findings that continued reporting probation is necessary to protect the community of the interests of justice? The
Yes,
court
Your
may decline.
Yes, Your Honor. The court does have discretion under subsection 5 if it makes written findings. We would suggest that continued reporting probation is not necessary to protect the public. Specifically, the alleged victim in this matter is no longer in the area. That's no longer a factor. She's half a country away. Mr. Sparks has been dutifully complying with all conditions of probation. There's been no allegations of violation for the last year and 8 months. He's been able to maintain a single job that he's working full-time. Your Honor, we would state that there's no longer a requirement for reporting probation to maintain the safety of the public. But Your Honor is correct. Subsection 5 does allow for written findings if the court does believe that continued reporting is required to protect the safety of the public. We would state that under these facts, especially with the alleged victim no longer even being anywhere near the area, that it's no longer necessary. And the court does have discretion under 4 to either terminate or convert to admin. So there is some discretion even in subsection 4.
And if it was administrative probation, would Mr. Sparks still be required to not engage in coaching with minors or teach them? Would it still have those conditions?
I believe the conditions would still apply, yes, Your Honor. It's just the reporting, the check-ins, the cost of supervision, anything along those lines. Now, probation may be better equipped to answer that question than me, but I believe the conditions would still apply, or rather the restrictions.
Probation to
Your
enlighten
Honor,
them?
as far as I understand, he can't have special conditions on the admin probation.
Okay, thank you.
Well, there we go.
Mr. Sparks, when I was doing my homework, I did read through the arrest report. I did note that count 2 was dismissed.
Judge, if I may, just to make sure, I had an email forwarded to me from probation, and Officer Howe, his probation officer, based on the sexual aspects of this case and the nature of those charges, she does object to the early termination as well. So just to make sure we're all clear.
Your Honor, again, I think that's immaterial. The only thing that would prohibit this is if there was an agreement in the original plea and sentencing that early termination or conversion to admin was excluded. That was not done here.
I understand you. And Mr. Sparks, the appellate cases say no matter what the agreement says, the court can modify supervision. So I understand that, but that would control about this statute. So as I was doing my homework and reading through, the allegations that were in that arrest report, certainly your position as a school teacher jumps out at me. I mean, that position of trust and the violation of that position of trust is huge to the court, especially trust of children as a teacher. Because of the facts that are in the arrest report, the court does find that continuing reporting is necessary to protect the community for the interest of justice. And respectfully, your motion to terminate supervision is denied. Thank you, sir.
Thank you.
Mr. Durrell, thank you for a really good argument. I'm glad that you pointed out that statute. To the state, will you prepare a proposed order that has those findings in there? Because I have to make written findings.
So just to be clear, based on the allegations in the case and the violation of trust, then the court finds that
It's the allegations that are in the arrest report and the heightened duty of trust that a school teacher has, especially in relation to their students. Thank you, Mr. Cross.
Thank you, Your Honor. I don't believe I have anything else, if I may be excused.
Yes, sir. Thank you.
Thank you.
Since we've been working over an hour and a half, we're going to take a 10-minute recess, and then we'll come back and finish up the afternoon.
There's one, there was a VOP evidentiary that we've been waiting on the defendant, but he's not here. Can we go ahead and get a KPS issued?
We can do that. So which case is that with the defendant's?
Nathan Nichols.
Ryan Morrow for Nathan Nichols, Your Honors, is 20 CF 3249. We were set for an evidentiary hearing at 2:30 today.
Yes, sir. And it's now 3:15.
State
So
request a KPS, Your Honor.
a KPS will be issued for Mr. Nichols. Now we'll take a 10-minute recess.
May I be excused, Your Honor?
Yes, sir.
All rise, please, court is recessed.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Time, you ready?
Are you on me up there now?
If you've been here longer than all the other private counsel.
Yeah, I'm Michael Weinstock on behalf of Adrian Miller. This is case 08CF1034.
Yes, sir.
As I said in my motion to set aside the restitution order, the court ordered restitution. It was reserved in this plea agreement. However, the amount was not set, and the court issued a restitution order of $26,000 or something like that without, emphasize, without notice or the opportunity for him to be heard. In other words, a total violation of his due process. I'm asking the court to set aside the restitution order.
To this statement.
Your Honor, we would respectfully object. I'm going to hand the court in defense as well. 2 cases and 1 statute. The 2 cases, it's a little bit of a tough thing to find direct cases on, so I kind of was aiming at finding the parts of the law that I think would help illustrate or shed some light on this particular scenario. In San Domino, State versus San Domino, just for the record, it's 217 Southern 3D 110. That actually talks about the jurisdiction that a trial court has over these particular orders. And I provided 2 cases. One case, the San Domino case, discusses the continuing jurisdiction over civil liens and restitution orders. In that case, and I actually highlighted it, it states that the statute gives the trial court continuing jurisdiction over the convicted offender for the sole purpose of entering civil restitution lien orders for the duration of the sentence and up to 5 years from release from incarceration or supervision, whichever occurs later. And this explains that section 960.292, section 2, permits the trial court to retain jurisdiction over a convicted offender for a period of 5 years from the release date of supervision. I've also provided this court with that statute, 960.292, subsection 2, and I highlighted the pertinent part that I wanted to bring to the court's attention. I also provided the court with State versus Maddox, which is 159 Southern 3rd 267. And in that part, I simply highlighted because I just wanted to illustrate also from the probationary standpoint, there it is held that the trial court is divested of jurisdiction over a probationer once the term of probation expires. So once I've set that out, I want to look back at the record here that we have. If we look at and I'm going from the clerk site, this originally occurred in 2008. There was a plea agreement that was executed and which restitution was reserved, I believe it was on June 25th of 2008.
July.
July, I'm sorry, yes, July, I'm sorry, 25th, 2008. Then in October 2nd of 2008, an order for restitution was then entered into. And I want to bring the court's attention specifically to the last clause in that order for restitution, which very clearly states, order that this is without prejudice to the defendant to contest the amount of restitution within 15 days of this order. As the court can see, there was never any objection by the defendant after that was entered into. And to kind of piggyback off of that, even on, hold on, I'm going to bring up the date. Even on October 23rd of 2013, when this court was tasked with an amended motion to modify probation and/or terminate probation, the defendant pled in that motion that it was ordered to pay restitution on this case in the amount of $55,302.77. And nowhere in that motion did it state that the defendant ever objected to that. That would have been the point in time, because this court still maintained jurisdiction over the defendant at that point to have brought any objections with respect to not having been heard or due process or anything of that nature. The only thing the defendant states in that motion to set aside the restitution is that the defendant cannot currently afford to pay the court costs, fines, probation fees, and restitution. It never states anything. This was back in 2013, 5 years after the original order for restitution had been granted, 5 years after that specific provision was stated where the defendant had 15 days to object, and it wasn't objected to then. Now we're fast forwarding almost 10 years later to this point in time, and now they're objecting to this restitution amount. It's the state's position that A, this court doesn't have jurisdiction. It's stated very clearly in 96292 that when you're talking about the civil lien orders and a trial court maintaining jurisdiction, it is for 5 years after a period of incarceration or after the supervision ends. Supervision was terminated, according to the court record, in 2013. So 5 years from that would have been 2018. This wasn't timely filed. However, even if this court finds that it does have that jurisdiction, there still is the issue of the fact that at multiple instances throughout the timeline of this case, this objection could have and should have been brought, and it never was until 15 years later. So for those reasons, the state respectfully requests that this court deny this motion and keep the restitution order and the civil lien order in place as it stands.
Thank you. Mr. Weinstock?
Well, what the prosecutor said, most of it is correct, but he's forgetting the fact that this court, you in particular, on 19th day of November 2013, issued a civil restitution lien order of $27,590.03. And that was done without notice or opportunity for him to know what was going on, for him to appear, for him to contest it, or for him to do anything. He was not given his due process. And for that reason, we're asked the court to set it aside. And if the court wants to revise it later on, so be it. But this, the violation of his due process is evident, and therefore we ask the court to set it aside.
What was the date of that order, Mr. Weinstock?
It looks like it was filed on November 21, 2013. You signed it on 19 November. May I approach with a copy?
That'd be great, yes, sir. I do have a copy of the November 12th. It says restitution to civil lien. I don't have that.
If like I believe this was included in my motion as attachment B, Bravo. Yeah, I approach?
I do have that, Mr. Weinstock. Thank you. Well, I've got Judge Remington's, and I do have that one. Yes, sir. Because it was so old, I did ask them to pull up, and I looked at the plea and sentencing agreement to see what was in that. It was so old it wasn't showing on the computers, and they pulled it up, and In that it just says restitution, but it didn't give an amount.
Right.
And you were the original attorney, so
I was not.
Oh, I thought you were.
No.
Okay. I saw your name on something previous.
I came to you back in 2013, I believe it was, to modify his probation, to get him off probation early. And you denied it.
They were going
But then we had to come back twice more.
They were going to violate me if I didn't go that route either way, because I didn't have the restitution paid. So in order to do it properly, we had to go that route. That way I made sure I wasn't violated and served jail time.
Yes, sir. So 2013, the civil restitution lien order. Still 5 years after that would be 2018, right?
Correct, Your Honor.
I don't believe there's a time limit on violation of due process.
And I smile, I think about the appellate, what goes up on appeal, and they talk about fundamental rights, whether you can waive those or not. I think it'd be hard pressed for the court to say that Mr. Miller expressly waived it, because I don't see any express waiver of it. But Mr. Miller, I do have concerns about, does the court still have jurisdiction for that? And I don't think I do. There's got to be finality to what the court does. So respectfully, the motion to set aside the restitution order is denied.
We have restitution, we have jurisdiction over it.
Say again?
Who are those who have jurisdiction over it?
Mr. Weinstock can advise you if you want to appeal it. You can certainly go to the First District Court, and they can give us all some guidance if that's what you want to do.
Your Honor, that's all I have.
To the state, on the trial that we have, the jury trial the end of next week, you can get me jury instructions and a proposed verdict form by the end of the day, Tuesday. That would be great.
The expectation is to have it to Mr. McKinney by the end of the day tomorrow, is what we're anticipating. So then it should be to you on Monday, Tuesday.
That'd be great. Thank you. Sounds good. Yes, Mr. Flowers, you ready?
Good afternoon, Your Honor.
Good afternoon, sir.
We are ready. My client is Martha Shawn Monk, Your Honor. She's appearing by Zoom. I think we indicated to the court she's in a treatment facility that should be released from in a few days. However, we're prepared to move forward with the plea. I have the written plea agreement with me, and she is standing by.
Good.
I believe. Your Honor, may I approach?
Please. Thank you, sir. Yes, sir. Thank you. So, Ms. Monk, your mic's muted, Ms. Watson.
Can we?
And Natasha is your client, Mr. Flowers?
My client is Martha Shawn Monk, who
is in the bottom left of that square, right under you, from what I can see on the screen.
Okay.
Looks like she's still muted.
She has someone assisting her, Your Honor, and that might be.
So, Ms. Monk, if you'll unmute your microphone, and I'll ask you to do that. That's Ms. Monk. Okay?
No, thank you.
Well, Ms. Watson.
Do we have Ms. Monk with us?
Which one is Ms. Monk? In the white shirt?
No.
Okay. Ms. Monk?
There she is. Ms. Monk, it's good to see you today. Your Honor, my apologies.
Okay, good. So, Ms. Snyder, I'm doing Ms. Monk's plea, and I'll come to you in a moment. Ms. Monk, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You can put your hand out. Ms. Monk, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Monk, let me look at the terms of it. So it's as charged, Mr. Powers?
In count one, it is, Your Honor. In count two, we anticipate, well, it's being dismissed. It's merged and dismissed into count one as charged, Your Honor.
Okay, well, because there's not a count two, it's just a separate case.
My apologies.
Gotcha. Nope. Okay, Ms. Monk, I do accept your plea. You're adjudicated guilty of count one, count two, well, I'm sorry, of the count in 22 CF 1932, adjudicated guilty in 22 TR 5106. Is there an adjudication on that?
You're on that.
I think the idea would that be that we merge and dismiss that.
Okay.
Yeah, I inartfully announced that, Your Honor, but that was the intention of the police, sir.
So that case is dismissed?
Yes, sir.
So Ms. Monk is sentenced to 30 days in the Okaloosa County Jail with credit for time served, and her credit is 124 days?
Yes, sir.
Good. Probation for 3 years. You'll need to perform 50 hours of community service work. You can buy that out. You'll need to attend multi-offender DUI school and also the victim impact panel. Your vehicle is impounded for 90 days. It's waived if there's no vehicle registered in your name. There'll be an interlock ignition device for 24 months. You'll need to submit to a substance abuse evaluation within 30 days from today. And if any treatment's recommended, begin that within 60 days from today. Your driver's license is suspended for 10 years. You'll have no alcohol or prescription medications without a valid prescription. When I say prescription, no regulated drugs are without a valid prescription. You'll need to pay the court cost of $683 and the fine of $5,000 and also the $250 fine. The cash bond is applied toward those fines and costs. Thank you, Ms. Monk. Good luck to you, ma'am.
Thank you, sir.
Thank you.
Your Honor, thank you, sir.
Thanks, Mr.
Ron, if she's placed on probation, we need her to report to the probation office.
Ms. Monk, where do you reside?
I live in Santa Rosa Beach, and I also go to Tallahassee's to take care of my father. He's 86 and a half.
Okay. Can you report to probation tomorrow?
Your Honor, if I may, she's in a treatment facility. We anticipate will be released within 7 to 10 days, and perhaps if she was to report within 24 hours of her release.
Which treatment facility?
What's the name of your facility, Ms. Monk? It escapes me.
Journey Door in Panama City Beach.
So probation, can she report after she leaves there?
Yes, sir. She needs to sign a release for probation, then we can verify she's there.
Okay. How is she going to do that?
She just signs a release for Journey Pure, and they'll talk to us.
Okay. Gotcha.
And we'll cooperate any way we can, Your Honor, in that effort.
Sounds good. Thank you, ma'am. Thank you, sir.
Thank you, sir.
Judge.
Yes, sir.
I believe that's all I have. My name is
Yes, sir. Thank you.
Thank you, Judge.
That's what we're about to argue.
Oh, okay.
So everything else here is
Thank you, Mr. Gomez.
Thank you. Good. We got a lot to resolve.
Yes, sir.
2 weeks.
Amazing, all the victim interaction.
Yeah.
Wow. Okay, who's next? Mr.
Judge,
McKinney?
I have Nicholas Snyder.
And don't forget, Ms. Schneider.
Is here for this sentencing.
Good, thank you.
Judge Nicholas Snyder is before the court in 22 CF 1860. This is on the docket as a sentencing.
Yes, sir.
And I believe that Ms. Davis reached out, and I believe we're in agreement with everything other than the 6 months community control, which is the basis what we're asking the court to rule on, essentially. And based on that, Mr. Snyder does travel out of state to New Orleans to help assist with his mother. That's who Vicki Snyder is. I would like to take some testimony from Ms. Snyder.
Okay. Ms. Vicki Snyder, if you'll take your microphone off mute. Good. If you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You can put your hand out. Mr. McKinney?
Ms. Snyder, can you hear me okay?
Somewhat, not very good, but I can.
Okay, if you can't hear something I say, please let me know. Could you please introduce yourself for the court?
My name is Vicki Schneider-Bomber. I'm Nick's mother.
Where do you currently live?
In Kenner, Louisiana.
Who lives within your household?
My uncle, he's 88, and my mom, she's 84, and now my daughter, Jessica, she's 38.
Is that Nicholas's sister?
Yes.
What's going on with Nicholas's sister?
Well, in January, she had a traumatic brain injury, and they were trying to put the old therapists, they want her in a skilled nursing facility, but the doctors here think that because of her age, because that's really a nursing home. But she's doing pretty good down here with the therapy, but I need to kind of take her back and forth to therapy a lot. And my mom's down, and she gets wheelchair.
So that sounds
Yeah,
like
so I just,
that sounds like you got a lot on your plate. Do you have a lot on your
yes.
plate?
Yes, I sure do. And Nick was helping before, but I really need a lot of help now.
And
Been moved down here.
does Nicholas travel to where you live in Louisiana and help you with the things that you just described for the court?
Yes, he does.
And is that something that you would like to continue to see happen?
Absolutely.
Do you have any other sons or daughters in the local area where you live that can help out?
No, I don't. I have a daughter in Florida, but she has a 4-year-old nonverbal autistic son she takes care of.
Okay. I have no further questions for Ms. Snyder.
To the state, questions for Ms. Schneider?
I don't have any questions.
Okay. Thank you, Ms. Schneider. You can certainly listen and watch, okay, if you want to.
Okay, thank you.
Thank you.
I have a few questions for Mr. Nicholas Snyder.
Mr. Schneider, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Mr. Snyder, you just heard your mom testify, right?
Yes, sir.
Is it your desire to go and help your mom?
Absolutely.
Or do you want to help out related to your sister?
Yes, definitely.
How often do you anticipate that you're going to be traveling to Louisiana if you're allowed regular probation and a travel permit, assuming that you do everything the right way in asking probation?
Well, really, I basically live there. Already as it is, you know, this is where I live, but I'm there so much. I mean, I'm there more than half the week. But my son's here, you know, my 4-year-old's here,
So your residence is in Florida?
Yes, sir.
And who lives at your house in your residence?
Right now, I'm staying with my father because I can't keep the house because I'm always back and forth, you know.
Can you introduce who's in the courtroom with you today?
Fiance, my son, Lisa, Elijah, everybody.
Thank you.
And it sounds like you're bouncing back and forth between your obligations here and trying to help out in Louisiana.
Yes, sir.
Is that the purpose of us asking this court to place you on probation without community control sanctions?
Yes, sir. Because I won't be able to travel for my community control. I won't be able to help.
Where do you work?
Landscaping.
I'm sorry, where do you work?
Landscaping.
And are you currently employed?
Yes, sir.
So you do that on top of trying to manage everybody else?
Yes.
Okay. I have no further questions for Mr. Snyder.
To the state?
Schneider, how does your trips to Louisiana, how is that affected by the probation that you already have for your misdemeanor case?
It's not. I have permission.
And I'm sorry, I couldn't hear that. You were away from the microphone.
It's not affected. I have permission from them.
Okay, thank you.
I'm just about finished with that. I just have some fines, so I haven't paid the fines.
And your shoplifters awareness course, have you completed that yet?
Yes, sir. Yes, ma'am.
And your community service work?
No.
I don't have any other questions, Judge.
Any redirect, Mr. McKinney?
No, Your Honor.
Okay, any other evidence from the defense?
No, Your Honor, just argument.
From the state, evidence?
No, Judge.
Mr. McKinney, argument?
The only issue that's really before the court is whether or not the court places Mr. Snyder on 6 months community control as a condition of his probation. Effectively, we've agreed to everything else here. The facts of this case relate to a leaf blower that was left out overnight at Blue Water Bay. Mr. Snyder picked it up. He knows he shouldn't have. He's entered a plea, he's taken responsibility, but he also wants to keep his responsibilities to his family. So that's why we are asking the court to impose the terms that we've effectively agreed to without placing Mr. Snyder on community control, which would preclude him being able to travel out of state to go help his family in Louisiana, which is near and dear to his heart, which is why he wanted to have a ruling from the court related to that issue.
Okay, to the state.
Judge, the state's concern is really a community protection issue. Mr. Snyder was released from a 3-year prison sentence from Walton County. He was just released from prison on January 29th of 2021. He then, on May 1st of 2022, he committed a petty theft at Walmart, and then this offense happened within just 2 months after that. So the state's concern is that the case that he also went to prison for was also a grand theft. It wasn't something that was unrelated to theft. So we have this pattern of committing thefts that Mr. Snyder has established. I understand, and I sympathize with Mr. Snyder's mother, but at this point, the problem is Mr. Snyder and theft. I understand that his sister has had a traumatic brain injury, and that his mom has now voluntarily decided to take care of her at this point. But the state feels that the community needs to be protected from Mr. Snyder at this point, and the 6 months of community control is an appropriate sentence at this time.
Okay, thank you. Mr. Snyder, when I was doing my homework, I thought, no, I'm not gonna do what your attorney was seeking. I was going to put you on 6 months community control because of your history and everything that the state stated. I didn't have the additional evidence from your mom and from you based solely on that. I'm adjudicating you guilty. You're sentenced to 2 years probation. Also, I looked at the terms of the supervision and made sure that there wasn't anything that you, being in Louisiana, would jeopardize those things. And I don't see, there's nothing that you have to be here to do. So, 2 years probation, restitution in the amount of $738.29 to Blue Water Bay Marina, perform 40 hours of community service work, have no contact with Ryan Hines, Hineley, Hinely. You have to enter and successfully complete the anti-theft course, no trespassing at Blue Water Bay Marina, and Madam Clerk, I'll hand you this, that has all this information, 290 Yacht Club Drive, Niceville, Florida. You need to pay the $40 per month cost of supervision. Court costs $515, $150 public defender's fee. Just know, Mr. Snyder, the hand that your family has been dealt with all these tragedies and everything, and your mom and your sister's need for you in Louisiana is the reason why I granted that. If you commit any new law violations, the outcome may be very different.
Yes, sir.
Thank you, sir.
And Judge, I want to make sure clear on the record that when he checks in with probation, he still has to seek travel permits to go out of state. That's something he has to address with probation prior to him actually going.
Correct.
Yes, sir. We can issue a trial permit 30 days at a time. However, you have to be available. You can't be gone 30 solid days because of the fact that you have to check in at probation. You have to be available for us to verify your residence and those sort of things.
Yeah,
And
I'm
you'll-
only leave for like 3 days at a time, and I come back.
Okay, you'll have to ask ahead of time, and you also have to make sure that you are current on your monetary obligations and that you're working towards all of your special conditions. Okay?
Thank you, Mr. Mayor.
Judge, if I can approach with a score sheet?
Yes, ma'am.
Thank you.
Thank you, Mayor.
No, you don't.
Okay, what else do we have this afternoon?